November 21st, 2025. A courtroom in Columbus, Ohio. A verdict was about to be read. The trial of Blendon Township Police Officer Connor Grubb. He'd been on trial for 2 weeks, charged with murder. The courtroom was packed. Media everywhere. Cameras, reporters, notebooks ready. Kiya Young's family sat in the front row. Her grandmother Nadine, holding hands with other family members. They'd waited over 2 years for this moment. 2 years of grief. 2 years of fighting. 2 years of demanding justice. And now, finally, a jury had made a decision. The judge entered. Everyone stood, sat back down. Silence. Heavy silence. The kind of silence that holds everything. Hope, fear, anticipation, dread. The judge asked if the jury had reached a verdict. The foreperson stood. Yes, Your Honor. The clerk took the verdict forms. Started reading. In the matter of the state of Ohio versus Connor Grubb, the charges were serious. Murder, felonious assault, involuntary manslaughter, 6 counts total. Each one read aloud. And after each charge, the same 2 words. Not guilty, not guilty, not guilty, not guilty, not guilty, not guilty, not guilty. All 6 charges. Acquitted on everything. Connor Grubb was walking free. Before we continue, like, share, subscribe, and turn on notifications. Because what happened to Kiya Young will make you question everything about justice. The courtroom erupted. Kiya's grandmother Nadine collapsed in her seat, screaming, sobbing, "It's not right. This is not right." Family members rushed to her, held her, cried with her. Other supporters were crying too, shaking their heads, unable to believe it. Not guilty, on everything. How? Connor Grubb sat at the defense table. He cried, tears running down his face. But these weren't tears of remorse. These were tears of relief. He was free. Free to go home. Free to walk out. Free from consequences. His family cried too. But their tears were different. Tears of joy. Their loved one was coming home. The media swarmed outside. Microphones. Cameras. Everyone wanting a statement. Kiya's family spoke through their attorney Sean Walton, his voice shaking. "This is an American tragedy," Walton said. "We have a dual system of justice in this country. One for police officers, and one for everyone else. Today proved that once again. The family vowed to continue fighting. Their civil lawsuit against Blendon Township will move forward. That fight isn't over. But the criminal case? The chance to see Grubb in prison? Gone. The jury said not guilty, and you can't be tried twice." Connor Grubb's attorney Mark Collins also spoke. Said Grubb was emotional, grateful. Collins said Grubb should never have been charged. Said this was always self-defense. Said the jury got it right. But the question everyone is asking is simple. How? How does a jury watch body camera footage and say not guilty? How does evidence not matter? How does a life not matter? Social media exploded within minutes. Twitter, Instagram, TikTok, Facebook, people furious, demanding answers, demanding accountability. The hashtags started trending. Justice for Kiya. Say her name. Police brutality. Black Lives Matter. Millions of people weighing in. Millions expressing outrage. Millions asking the same question. How did he walk free? News outlets covered it extensively. CNN, MSNBC, Fox News, local stations, national stations. Everyone talking about it. Everyone analyzing it. Everyone trying to understand how this happened. How a police officer shoots someone and faces no consequences. Civil rights organizations released statements. The NAACP, Black Lives Matter, the National Action Network, all condemning the verdict, all calling it a miscarriage of justice, all demanding systemic change, all saying this proves the system is broken. Legal experts weighed in. Former prosecutors, defense attorneys, constitutional scholars. Some said the verdict was correct based on Ohio law, based on self-defense standards, based on the burden of proof. Others said it was a travesty. said the jury got it wrong, said Grubb should be in prison. But here's what we know for certain. Kiya Young is dead. Her unborn daughter is dead. Her 2 sons are growing up without their mother. Her grandmother is raising them alone. And Connor Grubb is free. That's the reality. That's the result. That's what happened 5 days ago. This case started over 2 years ago. August 24th, 2023. In a Kroger parking lot in Blendon Township, Ohio. Something happened that day. Something that would lead to murder charges. Something that would divide public opinion. Something that would end in this verdict. But what actually happened? What did the body camera show? What was the evidence? What were the arguments? And why did the jury decide the way they did? To understand that, you need to go back to the beginning. Back to August 24th, 2023. Back to that Kroger parking lot. Back to the moment when Kiya Young's life intersected with Connor Grubb's. Back to the decisions that were made. The actions that were taken. The seconds that changed everything. Because this case isn't just about a verdict. It's about what led to that verdict. It's about a young woman, a police officer, an accusation, a confrontation, and a shooting. It's about whether that shooting was justified, whether it was reasonable, whether it was legal, and whether justice was truly served. The jury said not guilty, but you need to see the evidence for yourself. You need to know what happened. You need to understand the full story, and then you can decide, was this justice, or was this something else entirely? August 24th, 2023. Before the verdict, before the trial, before the national outrage. This is where it all started. A Thursday afternoon, Blendon Township, Ohio, a suburb of Columbus. Population about 10,000. Quiet neighborhoods, good schools, safe streets. The kind of place where nothing bad is supposed to happen. Kiya Young was 21 years old. Young, beautiful, full of life. She had dreams, big dreams. She wanted to go back to school, get her degree, become a social worker, help people, help families, help kids who needed someone to fight for them. She understood struggle. She'd lived it, and she wanted to turn that into purpose. Kiya had 2 sons, her world, her everything. One was 6 years old. The other was 3, beautiful boys. She loved them more than anything, spoiled them, cooked them steaks, bought them nice clothes, dressed them up, made them feel special, made them feel loved, because they were her reason for everything. Her grandmother, Nadine Young, helped raise the boys. Strong woman, loving grandmother. She'd watched Kiya grow up, watched her become a mother, watched her struggle, watched her try to build something better. Nadine was proud of her, proud of the woman she was becoming, proud of how much she loved those boys. In August 2023, Kiya was 7 months pregnant. Very pregnant. The kind where everyone notices, where strangers smile at you, where people offer help. Her belly was big, round, beautiful. This was her 3rd child, but her first daughter, a baby girl, due in November, just a few months away. Kiya was excited, had already started preparing, bought onesies, pink ones, tiny clothes for a tiny girl. She'd scheduled a maternity photo shoot, wanted to capture this moment, this precious time. She showed off her belly, proud, happy, hopeful about the future. She'd applied for public housing, Section 8 assistance, wanted her own place, her own home, where she could raise her 3 children, where they'd have space, stability, a foundation. She was on waiting lists, filling out paperwork, doing everything required, because she wanted better for her kids. That was Kiya Young, 21 years old, 7 months pregnant, mother of 2, soon to be mother of 3, working toward better, working toward more, working toward a future she'd never see. Thursday afternoon, Kiya had errands to run, needed groceries, household items, normal stuff. She drove to the Kroger on Sunbury Road. Big store, busy location. Everyone in the area shopped there. Kiya had been there before, many times, never had problems. Just another customer. She parked her car, got out, 7 months pregnant, moving carefully, protecting her belly. She walked into the store, grabbed a cart, started shopping, walking the aisles, looking at products, picking items, just living her life, just taking care of business, just existing. But someone was watching, a store employee. We don't know who, we don't know why, but someone noticed Kiya, watched her movements, and that employee became suspicious, made a judgment, made an accusation. Bottles of alcohol. The employee claimed Kiya took bottles without paying, put them somewhere, left without purchasing. The employee decided Kiya was stealing, was a thief, was a criminal. But here's what the employee didn't do. Didn't confront Kiya, didn't ask questions, didn't request a receipt, just watched, waited, let her walk through the store, let her head toward the exit, let her leave, and then called the police, reported a theft, reported Kiya young. Kiya had no idea she was being accused, no idea police were being called. She finished her shopping, walked out of the store, walked through the parking lot, got to her car, put her items inside, got in the driver's seat, buckled her seatbelt, started the engine, ready to leave, ready to go home, ready to continue her day. But 2 Blendon Township police officers were already responding. Officer Eric Moynihan had been nearby, helping someone locked out of their car, then got the alert. Possible shoplifter, female, still in parking lot. In her vehicle, he looked around, spotted Kiya's car, started approaching. Officer Connor Grubb responded too. Same call, same alert. 31 years old, trained officer, armed, supposedly knew how to handle situations, how to de-escalate, how to protect and serve. But what he was about to do would end 2 lives. Both officers walked toward Kiya's car. She was sitting in the driver's seat, engine running, seatbelt on, not fleeing, not speeding away, just sitting there, 7 months pregnant, about to leave. She saw them coming, 2 uniformed officers, walking toward her with purpose. She probably wondered why, probably didn't think it was about her. Officer Moynihan reached her window first, driver's side. Kiya's window was up. She cracked it slightly, just enough to hear. She looked confused, uncertain. "Ma'am, you need to get out of the vehicle," Moynihan said, his voice firm, direct, command. Kiya looked at him. "Why?" she asked, her voice uncertain. "What did I do?" Moynihan didn't explain, didn't tell her about the accusation, just repeated his order. "You need to step out of the vehicle now." Kiya hesitated. She was 7 months pregnant. Getting out wasn't easy. Her belly was huge, and she didn't understand. Why did she need to get out? "I didn't do anything," Kiya said, her voice defensive now, protective. She sensed something was wrong. Officer Grubb was moving, positioning himself, not beside the car, not behind it, but directly in front, blocking her path, standing where her car would need to drive to leave. The body cameras were recording. Both officers wore them. Everything about to happen would be captured. "Get out of the car!" Moynihan's voice was louder now, aggressive. This was a demand. Kiya shook her head. She was scared. A young pregnant woman being yelled at by armed men, not understanding why. And that's when Connor Grubb made his move. He reached for his gun, drew his service weapon, and pointed it directly at Kiya Young, through the windshield, at a pregnant woman in a parking lot. Kiya saw the gun, saw it aimed at her face, through the glass, and she asked a question captured on camera, a question that would haunt everyone who heard it. "Are you going to shoot me?" The officers kept yelling, both of them, demanding compliance, demanding she exit. Kiya's hands went to the steering wheel. She was panicking, making desperate decisions. She turned the wheel, to the right. Her foot must have moved, because the car started rolling. Not fast, not speeding, just rolling slowly forward. Grubb was in front of the car, in its path, And when the car moved toward him, he made his choice. He fired. One shot. Through the windshield. The bullet traveled through glass. Through air. Into Kiya Young's chest. She slumped immediately. Head dropped. Body went limp. The car kept moving. Slowly drifting. No one steering anymore. Until it hit the Kroger building. Came to a stop. Stop the car. Stop the car. The officers were yelling. At a dying woman. At someone who couldn't respond. They broke the window. Opened the door. Kiya's body started falling. They caught her. Laid her on the pavement. Blood everywhere. Coming from her chest. Pooling beneath her. Get medical. Moynihan was on his radio. Calling for help. But it was too late. Paramedics arrived. Rushed her to the hospital. Doctors tried everything. But the bullet had done too much damage. Kiya Young died. And so did her daughter. Her unborn baby girl. Kiya Young was dead. Her unborn daughter was dead. Shot by police. Over alleged shoplifting. Over bottles of alcohol that were never proven stolen. Someone had to tell the family. Someone had to make the call. The worst call. The call that changes everything. The call that ends your world. Nadine Young answered her phone. Kiya's grandmother. The woman who helped raise her. Who loved her. Who was raising Kiya's 2 boys. And someone on the other end told her the unthinkable. Kiya is dead. Shot by police. Kroger. Both her and the baby. Gone. Nadine collapsed. Screamed. How do you process that? How do you understand? Your granddaughter. Your great-granddaughter. Dead. Over shopping. Over an accusation. Over nothing. And then there were the boys. Kiya's sons. Ages 6 and 3. Too young to fully understand. Too young to comprehend death. But old enough to know mommy isn't coming home. Old enough to cry. Old enough to ask why. How do you tell a 6-year-old his mother was killed by police? How do you explain that to a 3-year-old? Where's mommy? When is she coming back? Why can't I see her? Questions with no good answers. Questions that break your heart. Questions that will haunt them forever. Nadine would raise them now. Both boys. Permanently. Not just helping. Not just babysitting. But being their mother. Their father. Their everything. Because Kiya was gone. And their baby sister they'd never meet was gone too. The news spread fast. Local media picked it up first. Then national. Pregnant woman shot by police in grocery store parking lot. The headlines were shocking. The details were horrifying. People wanted answers. But the police had their story ready. Their narrative. Their version. And they told it first. Before anyone could question. Before the family could speak. Before the truth could emerge. According to Blendon Township Police, officers responded to a shoplifting call. Approached a suspect in a vehicle. Ordered her to exit. She refused. Became non-compliant. The vehicle moved toward an officer. The officer feared for his life. Discharged his weapon. The suspect was struck. Transported to hospital. Pronounced deceased. The incident is under investigation. Clean. Simple. Justified. She refused to comply. The car moved. He feared for his life. He shot. She died. Tragic but necessary. That's what they wanted people to believe. But there was a problem. Body cameras. Both officers wore them. Everything was recorded. Every word. Every action. Every second. The truth was on those cameras. And eventually people would see it. The community started demanding answers. Who was the officer? What's his name? Why was deadly force used over shoplifting? Where's the body camera footage? When will it be released? Blendon Township Police refused to release the officer's name. They cited Massey's Law, an Ohio law designed to protect crime victims. The law prevents disclosure of victim identities. And police claimed Officer Connor Grubb was a victim of attempted vehicular assault, because Kiya's car moved toward him. So he was the victim, not Kiya, not the pregnant woman who died, not the baby who never got to live. The officer who killed them was the victim. Think about that logic. A cop shoots a pregnant woman. kills her and her unborn child, and claims victim status, claims protection, claims his name needs to be hidden, while Takiya's name is everywhere, while her face is on every news station, while her family grieves publicly. The cop gets to hide, gets to be anonymous, gets to be protected by the very law meant to protect people like Takiya. Days passed. No body camera footage. No transparency. Just statements. Just press releases. The investigation is ongoing. No further details at this time. We cannot comment on pending investigations. Standard responses. Standard delays. Standard stonewalling. Meanwhile, Officer Connor Grubb went home. He wasn't arrested, wasn't charged, wasn't even fired, just placed on paid administrative leave, meaning he sat at home, getting his full paycheck, full benefits, paid to do nothing, while Takiya's family planned 2 funerals, while her sons cried for their mother, while Nadine tried to hold everything together. Grubb collected paychecks. The family hired attorneys. Sean Walton and his legal team, civil rights lawyers. They wanted answers. They wanted accountability. They wanted justice. They demanded the body camera footage. The public has a right to see. The family has a right to know. What really happened? What does the video show? The lawyers filed requests, made demands, applied pressure. And finally, after 8 days, Blendon Township released the footage. September 1st, 2023, 8 days after Takiya's death. The body camera video went public, posted online, available for anyone to watch. The family watched it first, in a private room, with their attorneys, preparing themselves for trauma, for pain, for watching Takiya die. The video started playing. Officers approaching Takiya's car, demanding she get out. Takiya refusing, saying she didn't do anything. Officers getting louder, more aggressive, cursing at her. Grubb stepping in front of the car, drawing his gun, pointing it through the windshield, at a pregnant woman. Takiya's voice, clear on the audio. "Are you going to shoot me?" Then the car rolling. Slowly, so slowly. The gunshot. Takiya slumping forward. Officers yelling, "Stop the car!" At a dying woman. The chaos. The blood, the death. The family was devastated, watching their loved one die, watching it happen in real time, watching a preventable tragedy, watching what looked like murder, not self-defense, not justified force, but a cop shooting a pregnant woman over alleged shoplifting. The video went public that same day. Millions of people watched. The reaction was immediate and fierce. Outrage everywhere. How does this happen? How is this justified? How is this legal? Pregnant woman, in a parking lot, over shoplifting, shot through the windshield. Social media exploded. Hashtags trended. Justice for Takiya. Say her name. Police accountability. People posting, sharing, demanding answers. Celebrities weighed in. Athletes spoke out. Politicians made statements. Everyone saw the video. Everyone had an opinion. And most agreed. This was wrong. Civil rights organizations released statements. The NAACP called it unconscionable. Black Lives Matter demanded charges. The National Action Network called for immediate arrest. Everyone saying the same thing. Connor Grubb killed Takiya Young, and he needs to be held accountable. Protests started. In Blendon Township, in Columbus, in cities across America, people marching, holding signs, chanting Takiya's name, her face on posters, her story being told, her life being honored, demanding that her death not be in vain. October 4th, 2023, over a month after the shooting, the medical examiner released official findings. Takiya Young's death, homicide. Her baby's death, homicide. 2 homicides, caused by gunshot wound inflicted by police. Homicide, the official ruling, not accident, not justified, not self-defense. Homicide, one person killed another person. Connor Grubb killed Takiya Young, killed her baby. The coroner said so. The evidence said so. The body camera said so. But Grubb was still at home, still on paid leave, still collecting paychecks, still free, still uncharged, still protected. The case went to a grand jury to decide if charges should be filed. The family waited. The community waited. The nation watched. Would Connor Grubb finally face justice? Months passed. The family waited. The community waited. The nation waited. Would Connor Grubb be charged? Would he face justice? Would he be held accountable for killing Kiya Young and her unborn daughter? Or would he walk away, like so many cops before him, protected by the badge, protected by the system, protected by a justice system that rarely holds police accountable? The wait was torture. Every day without charges felt like another injustice, another insult, another message that Kiya's life didn't matter, that her baby's life didn't matter, that police can kill with impunity, can claim fear, can claim self-defense, can go home while families bury their dead. Kiya's sons were asking questions. Where's mommy? When is she coming back? Why did the police hurt her? Nadine tried to answer, tried to explain, tried to help them understand something she couldn't understand herself. How do you tell children their mother is never coming home? How do you make that make sense? December 2023. For months after the shooting, finally, an announcement. A special prosecutor had been appointed. Not the local prosecutor. Not someone from Franklin County, but someone from outside, from Montgomery County in Dayton, to avoid conflicts of interest, to ensure fairness, to handle the case properly. The special prosecution team consisted of 3 attorneys: Aaron Claypool, Richard Glennon, Daniel Brandt, all from the Montgomery County Prosecutor's Office. Experienced prosecutors, people who'd handled serious cases before, people who understood what was at stake. They would review all the evidence, the body camera footage, the witness statements, the medical examiner reports, the forensic analysis, everything, and then present it to a grand jury. Let citizens decide if charges should be filed. The grand jury process is secret, closed to the public, closed to the media. Only the prosecutors and jurors are present. The prosecutors show evidence, play videos, call witnesses, explain the law, and the grand jury decides, is there probable cause? Should this officer be charged? Should this go to trial? More months passed. Still no decision. Still no charges. Still waiting. The family was losing hope, starting to believe maybe Grubb would never be charged. Maybe the system would protect him. Maybe justice would never come. August 13th, 2024, nearly a year after Kiya's death. Finally, the announcement came. The grand jury had reached a decision. Connor Grubb had been indicted, charged, formally accused of crimes. The charges were serious, very serious, 4 counts of murder, 4 counts of felonious assault, 2 counts of involuntary manslaughter, 10 charges total, each carrying potential prison time, real prison time. If convicted of murder, Grubb faced 15 years to life in prison. The 4 murder counts covered both victims, Kiya and her unborn daughter. The grand jury said both deaths were criminal. Both deaths deserve charges. Both deaths deserve justice. August 14th, 2024, the day after the indictment, Connor Grubb turned himself in, was arrested, processed, booked, fingerprinted, mugshot taken. The same procedures he'd done to countless others as a cop. Now being done to him. Now he was the criminal, the accused, the defendant. Grubb appeared in court via video from jail. For his arraignment, the formal reading of charges. His attorney Mark Collins stood ready. Experienced defense attorney. Had defended cops before. Knew how to fight these cases. Knew how to win. The judge read all 10 charges. Asked Grubb how he pleaded. Grubb's response was firm, clear. Not guilty. Not guilty to all charges. Not guilty to murder. Not guilty to assault. Not guilty to manslaughter. Not guilty to killing Kiya Young and her baby. The defense strategy was obvious from the start. Self-defense. Grubb feared for his life. The car was a weapon. The car was moving toward him. He believed he was going to be struck, run over, killed. He had seconds to decide, and he chose to protect himself. That's not murder. That's survival. That's justified. But the prosecution had evidence. Strong evidence. The body camera footage showing everything. Expert witnesses ready to testify. Accident reconstruction analysis. Use of force experts. Medical testimony. Everything pointing to one conclusion. This wasn't self-defense. This was unnecessary, unjustified, criminal. The family felt relief mixed with anger. Relief that charges finally came. That someone finally said what Grubb did was wrong. That Takiya's life mattered enough to prosecute. But anger too. Why did it take a year? Why did Takiya have to wait a year for justice? Why did her family have to suffer a year of uncertainty? Nadine Young spoke to reporters outside the courthouse. Her voice shaking with emotion. My granddaughter is dead. My great-granddaughter is dead. It took a year for someone to say that matters. A year. Tears streamed down her face. The pain was visible. Raw. Real. The family also filed a civil lawsuit, separate from the criminal case, against Blendon Township, against the police department, against Police Chief John Belford, against everyone who played a role, everyone who enabled what happened. The civil suit made serious allegations. That Grubb wasn't properly trained, wasn't properly supervised, that he recklessly escalated the situation, created the danger himself, manufactured the threat, then used that manufactured threat to justify killing Takiya. The lawsuit also pointed to policy violations. Blendon Township Police Department policy explicitly states officers should move out of the path of approaching vehicles, should not stand in front of them, should not use vehicles as justification for deadly force, but move, create distance, preserve life. Grubb did the opposite, violated policy, and killed Takiya because of it. The criminal case moved forward. Slowly. Legal cases always move slowly. Motions filed. Hearings scheduled. Discovery exchanged. Both sides building their cases. Preparing for trial. Preparing for war. The defense filed motions to dismiss. Argued insufficient evidence. Argued Grubb's actions were justified under Ohio law. Argued self-defense. The judge denied most motions, but granted one crucial motion during trial. November 18, 2025. During the trial itself, the judge dismissed 4 charges, 2 counts of murder and 2 counts of felonious assault, all related to Takiya's unborn daughter. Gone. Dismissed. No longer part of the case. Why? The defense argued successfully that there was no evidence Grubb knew Takiya was pregnant. No evidence he saw her belly. No evidence he knew about the baby. And without that knowledge, without that awareness, those charges couldn't stand under Ohio law. The family was devastated. For charges gone. Takiya's daughter's life didn't count? Didn't matter? She was 7 months developed. Almost ready to be born. Almost ready to live. And now her death wasn't even a crime? But 6 charges remained. 2 counts of murder for Takiya. 2 counts of felonious assault. 2 counts of involuntary manslaughter. 6 chances at justice. 6 chances at conviction. 6 chances to hold Connor Grubb accountable. The trial was set. November 2025. Over 2 years after Takiya's death. The family prepared themselves. Prepared to sit in that courtroom every day. To watch the trial. To hear testimony. To see the body camera footage again. To relive the worst day of their lives. To fight for Takiya. To fight for justice. As we continue, like, share, subscribe, and turn on notifications. November 5th, 2025. More than 2 years after Takiya's death, the trial finally began. Connor Grubb would face a jury, would face the evidence, would face judgment for what he did on August 24th, 2023. The trial was held in Franklin County Common Pleas Court in Columbus. Judge David Young presiding. No relation to Takiya despite the shared last name. The courtroom was packed. Media everywhere. Cameras outside. reporters with notebooks, Takiya's family in the front row, Nadine Young, other relatives, friends, supporters, all there to witness, all there to fight, all there for Takiya. Connor Grubb sat at the defense table, his attorneys beside him, Mark Collins and Kimberly Stevens, both experienced, both ready, both confident they could win. Grubb looked different than in his mugshot. Clean-shaven, suit and tie, calm, composed, like he wasn't on trial for murder. Jury selection took days. Potential jurors questioned extensively. Have you seen the body camera footage? Do you have relationships with police? What are your views on law enforcement? Can you be fair? Can you follow the law? Can you set aside your emotions? The final jury was selected. 12 people, 9 women, 3 men, only 1 black juror. They would decide Connor Grubb's fate. They would determine if he committed murder, or if he was justified. They held Takiya's justice in their hands. The charges were read. 2 counts of murder, 2 counts of felonious assault, 2 counts of involuntary manslaughter, 6 counts total after the 4 charges related to the baby were dismissed. If convicted of murder, Grubb faced 15 years to life in prison. Real consequences, real accountability, real justice. Opening statements began. Special Prosecutor Aaron Claypool stood before the jury, told them what this case was really about. A young pregnant woman, in a parking lot, accused of shoplifting. Officers arrived, escalated, created danger, and one officer shot her through the windshield, killed her baby, over alleged theft. Takiya Young wasn't a threat, Claypool said. She was trying to get away. She was scared. And Officer Grubb shot her anyway. This wasn't self-defense. This was murder. Then came the defense. Mark Collins stood, looked at the jury, told a different story. A story of split-second decisions, of deadly threats, of an officer fighting for his life. He said Takiya's car was a weapon, said it was moving toward Grubb, said Grubb felt it strike his legs, felt himself being lifted, believed he was about to die, and therefore shooting was justified. What happened to Takiya Young is a tragedy, Collins said, but it's not a crime. Officer Grubb believed his life was in danger. He acted to protect himself. That's not murder. That's survival. The prosecution called 14 witnesses, store employees, bystanders, first responders, medical examiners who described Takiya's wound, the bullet entering her chest, destroying her heart, causing instant massive trauma. She never had a chance. The baby never had a chance. But the most important witness was Officer Eric Moynihan, Grubb's partner, the other officer at the scene, the one whose body camera captured everything. Moynihan testified for the prosecution, against his fellow officer. Did you feel threatened by Takiya Young? The prosecutor asked. No, Moynihan said clearly. She never did anything that made me think she was a threat. He said he didn't draw his weapon, didn't feel endangered, didn't expect Grubb to shoot, was surprised when he heard the gunshot. The defense tried to undermine him, suggested he was lying, covering mistakes, changing his story after Grubb was charged. But Moynihan held firm. He wasn't scared, didn't feel threatened, and didn't think deadly force was necessary. The prosecution called expert witnesses. Seth Stoughton, a professor and policing expert. He'd testified in other major cases. Derek Chauvin, George Floyd, Adam Coy, Andre Hill. He analyzed what Grubb did. His conclusion was damning. Officer Grubb created the danger, Stoughton testified. He positioned himself in front of the vehicle. This was tactically unsound, unreasonable, against policy. Officers are trained to move out of the path of vehicles, not stand in front of them. Grubb did the opposite. Stoughton explained that Grubb manufactured his own fear, put himself in danger deliberately, then used that manufactured danger to justify deadly force. That's not reasonable. That's not justified. That's not legal. The defense had their own expert, Kevin Davis, a use of force consultant. He argued Grubb was justified, said the car was a deadly weapon, said Grubb perceived imminent danger, said shooting was reasonable under the circumstances. When a vehicle moves toward you, that's a deadly threat, Davis testified. Officer Grubb had seconds to respond. He did what he was trained to do. The body camera video was played, multiple times, for the jury, for the witnesses, for the experts. Everyone saw it. The full interaction. Kiya in her car. Officers demanding she exit. Grubb stepping in front, drawing his gun. Kiya asking, "Are you going to shoot me?" The car rolling slowly. The gunshot. Kiya slumping. Everything captured. Everything documented. Some jurors cried, held tissues, looked away. The video was painful, brutal. Pregnant woman being killed. In a parking lot. Over alleged shoplifting. It was hard to watch. Hard to process. Hard to understand. Connor Grubb never testified. Never took the stand. Never faced cross-examination. Too risky. Too many questions he couldn't answer. Instead, the defense submitted a written statement. Read by an investigator. Not questioned. Not challenged. In the statement, Grubb claimed he feared for his life. Said the car was accelerating toward him. Said he felt it hit his legs. Felt himself being lifted off the ground. Believed he was about to be run over. Had no choice but to shoot. The prosecution wanted to question him. Wanted to ask why he stood in front of the car. Why he didn't move. Why he escalated. Why he shot a pregnant woman. But they couldn't, because Grubb never testified. After 6 days of testimony, both sides rested. The evidence was in. Now came closing arguments. Before we continue, like, share, subscribe, and turn on notifications. Because what happened to Kiya Young will make you question everything about justice. November 19th, 2025. The courtroom was packed. Every seat filled. Media, family, supporters, everyone waiting. The evidence was in. The witnesses had testified. The body camera had been played. Now came closing arguments. The final chance for both sides to speak, to persuade, to convince 12 jurors. Special Prosecutor Erin Claypool stood first. She walked toward the jury, made eye contact. Her voice was strong, clear, emotional but controlled. "Connor Grubb is a liar," she began. Direct, blunt, no sugarcoating. He lied about what happened that day. He lied about feeling the car hit him. He lied about being in danger. And he lied to justify killing Kiya Young. She walked them through the evidence. The body camera footage, frame by frame, showing Grubb stepping in front of the car, positioning himself deliberately, creating the confrontation, creating the danger. "Look at his position," Claypool said. "He chose to stand there, chose to block her path, chose to draw his gun. Kiya Young didn't create this situation. Officer Grubb did." She talked about the car's speed. Slow, rolling, not accelerating hard, not speeding. The kind of slow movement you see in parking lots every day. Not the kind that justifies killing someone. "Officer Moynihan was right there," Claypool continued, "standing at the driver's window, and he didn't feel threatened, didn't draw his weapon, didn't fear for his life, because there was nothing to fear. Kiya Young was trying to get away, not attack." She reminded the jury about the expert testimony. Seth Stoughton, his analysis, his conclusion that Grubb violated policy, violated training, created his own danger, then used it to justify murder. "Officer Grubb had choices," Claypool said. "He could have stepped back, could have moved aside, could have let her go. It was shoplifting, a misdemeanor, not worth dying over, definitely not worth killing over. But he chose to shoot, chose to kill, chose murder." She talked about Kiya, 21 years old, pregnant, mother of 2, with dreams, with plans, with a future, all stolen by one bullet, one decision, one cop who valued compliance over life. Kiya Young asked him a question. Claypool said, her voice breaking slightly, She looked at that gun pointed at her face and asked, "Are you going to shoot me?" And seconds later, he did. He shot a pregnant woman through the windshield. That's not self-defense. That's murder. She sat down. The prosecution rested. Now it was the defense's turn. Mark Collins stood, confident, composed. He approached the jury with a different energy, sympathetic, understanding, like he was asking them to see reason. "This is a tragedy," Collins began. "Everyone agrees on that. Kiya Young's death is tragic. Her baby's death is tragic. Officer Grubb having to make that split-second decision is tragic. But tragedy doesn't equal crime." He walked them through Grubb's perspective. What Grubb saw, what Grubb felt, what Grubb feared in that moment. Officer Grubb saw a car moving toward him, Collins said. Not rolling slowly like the prosecution claims, but moving, accelerating, coming at him. He felt it strike his legs, felt himself being lifted, believed he was about to be run over, about to die. In that split second, he had to choose, and he chose to live. Collins attacked the prosecution's witnesses, questioned Moynihan's credibility, suggested he changed his story after Grubb was charged, suggested he was protecting himself, covering his own mistakes. He attacked the expert testimony, said Seth Stoughton wasn't there, didn't feel what Grubb felt, didn't see what Grubb saw, was just analyzing video after the fact with all the time in the world. It's easy to judge with hindsight, Collins said. Easy to analyze video frame by frame in a comfortable office. But Officer Grubb didn't have that luxury. He had seconds, milliseconds, and he made the choice to survive. Collins reminded the jury about Ohio law, about self-defense, about reasonable belief. He argued that if Grubb reasonably believed he was in danger, then shooting was justified. Even if he was wrong, even if the danger wasn't as great as he perceived. Reasonable belief is what matters. The prosecution wants you to second-guess every decision Officer Grubb made. Collins continued. Why did he stand there? Why didn't he move? But that's not the legal standard. The question isn't what you would have done. The question is, did Officer Grubb reasonably believe his life was in danger? And the answer is yes. He talked about the burden of proof, beyond reasonable doubt. He said the prosecution hadn't met it, said there were too many questions, too much uncertainty, too much room for doubt. If you have doubt about whether Officer Grubb genuinely feared for his life, you must acquit, Collins said firmly. That's the law. That's justice. This is a tragedy, but it's not a crime. He sat down. The defense rested. Both sides had made their arguments. Now it was up to the jury. Judge David Young gave jury instructions, explained the law, explained the charges, explained what the jury must find to convict, or to acquit, the legal standards, the burden of proof, the elements of each crime. For murder, the jury must find that Grubb purposely caused Kiya's death, that he intended to kill her. That's murder. For felonious assault, they must find he knowingly caused serious harm, that he understood his actions would hurt her. For involuntary manslaughter, they must find he recklessly caused death, that he took unjustified risks that resulted in death. Self-defense was the key issue. If Grubb reasonably believed he was in imminent danger of death or serious harm, and used reasonable force to defend himself, then he's not guilty. Even if his belief was mistaken, as long as it was reasonable. The jury retired to deliberate. 12 people, 9 women, 3 men. They would review evidence, watch videos, debate, argue, try to reach unanimous decisions on all 6 charges. The family waited outside the courtroom. Nadine Young, Kiya's relatives, her friends, all waiting, hoping, praying for justice, praying the jury would see what they saw, would convict, would hold Grubb accountable. Hours passed. Then more hours. The jury deliberated through the afternoon. Into the evening, they asked to review evidence, wanted to watch the body camera footage again, wanted to hear certain testimony again. The judge accommodated, sent them back to continue deliberating. The first day ended. No verdict. The jury went home, would return the next morning to continue. The family went home too, exhausted, anxious, unable to sleep, unable to think about anything except what those 12 people were deciding. November 20th, 2025. Day 2 of deliberations. The jury returned, continued their work, continued debating, continued trying to reach consensus. More hours passed. Still no verdict. Then something happened. One of the jurors became ill, sick enough that they couldn't continue. The judge had to make a decision. Replace the sick juror with an alternate. But that meant starting deliberations over, from scratch, with a new person who hadn't been part of the discussions. The alternate juror was seated, and deliberations began again. All those hours of discussion, all those debates, all that progress, gone. Starting over. The family was devastated. More delays, more waiting, more uncertainty. How much longer? How much more could they endure? November 21st, 2025. The new jury deliberated. 12 hours total with the new juror. Finally, they sent word. They'd reached a verdict. They were ready. November 21st, 2025. 2:30 p.m. The call came. The jury had reached a verdict. After 12 hours of deliberations with the alternate juror. After replacing the sick juror and starting over. After all the waiting, all the testimony, all the evidence, they had decided. The courtroom filled quickly. Kiya's family rushed back. Nadine Young, relatives, friends, supporters, media packed the gallery, cameras ready outside. Everyone knew this was the moment that would determine if Connor Grubb would face consequences or walk free. Connor Grubb entered with his attorneys. Mark Collins, Kimberly Stevens. Grubb looked nervous, his face tense. This was it. His freedom, his future, his life, all depending on what 12 strangers decided. The jury filed in. Their faces gave nothing away. No smiles, no tears, just serious expressions. The weight of their decision visible on every face. Judge David Young called the court to order, asked if the jury had reached verdicts. The foreperson stood. A woman, middle-aged. She held the verdict forms. "Yes, Your Honor," she said, her voice steady, calm. The clerk took the forms, started reading. The courtroom was silent, completely silent. You could hear breathing, heartbeats, fear. In the matter of the state of Ohio versus Connor Grubb, case number 24-3842, count 1, murder. The clerk paused. The silence deepened. Time seemed to stop. "We the jury find the defendant, Connor Grubb, not guilty." Gasps. Immediate gasps. From the family section. From supporters. "Not guilty. On murder. The first charge. Not guilty. Count 2 murder." Another pause. Another moment of suspended time. "Not guilty." More gasps. Louder now. Nadine Young's hand went to her mouth. Her eyes filled with tears. Count 3, felonious assault. Not guilty. Count 4, felonious assault. Not guilty. Count 5, involuntary manslaughter. Not guilty. Count 6, involuntary manslaughter. Not guilty. 6 charges. 6 not guilty verdicts. Acquitted on everything. Connor Grubb was walking free. The courtroom erupted. Nadine Young collapsed in her seat, screaming, sobbing. "It's not right. This is not right." Her family rushed to her, held her, tried to comfort her. But there was no comfort, no consolation, just devastation. Other supporters were crying, shaking their heads. Some stood up, yelling, "No, this is wrong." Court officers moved toward them, asking for order, asking for calm. Connor Grubb broke down, sobbing at the defense table. His attorneys hugged him, patted his back. His family in the gallery cried too. But these were different tears. Relief, joy, gratitude. Their loved one was free. Judge Young banged his gavel, called for order. The courtroom slowly quieted. But the pain was palpable, thick, suffocating. The judge thanked the jury for their service. Dismissed them. They filed out. Some looked shaken, others stoic. They'd done their job, made their decision. Now they could go home. Grubb was officially discharged. Free to leave. Free to walk out of that courtroom. Free from all charges. Free from consequences. Outside the courthouse, the scene was chaos. Protesters had gathered. Signs everywhere. Justice for Kiya. Black Lives Matter. Police accountability now. When news of the verdict spread, the crowd grew angry, chanting, shouting, demanding answers. Kiya's family held a press conference. Sean Walton, their attorney, spoke first, his voice shaking with controlled rage. "This is an American tragedy," Walton said. "We have a dual system of justice in this country, one for police officers, and one for everyone else. Today proved that once again." Nadine Young could barely speak. Her voice broke, her pain raw and visible. "My granddaughter is dead," she said through tears. "My great-granddaughter is dead, and the man who killed them is walking free. How is that justice? How is that right? Someone tell me how that's right." No one could answer, because there was no good answer. Just a broken system, just another family devastated, just another black woman whose life didn't matter enough. Connor Grubb's attorney also held a press conference. Mark Collins stood with Grubb beside him. Grubb's eyes were red from crying. "Officer Grubb is relieved," Collins said. "This has been an incredibly difficult time for him. He never wanted any of this to happen. He's a good officer who made a split-second decision to protect his life." The jury understood that. The jury got it right. Collins criticized the protests, called them inappropriate, said they created pressure on the jury, said Grubb should never have been charged in the first place. "This was always self-defense," Collins said. "Officer Grubb feared for his life. That fear was reasonable, and the jury recognized that." Grubb said nothing, just stood there, free, alive, while Kiya Young remained dead, while her baby remained dead, while her sons remained motherless. Social media exploded. Within minutes, Twitter, Instagram, TikTok, Facebook, everyone posting, everyone reacting, everyone outraged. Hashtag Justice for Kiya trended nationwide. Millions of posts, millions of people expressing disbelief, expressing anger, expressing grief. How does this happen? How does a cop kill a pregnant woman and walk free? Celebrities weighed in. Athletes, actors, musicians, politicians, civil rights leaders. Everyone saying the same thing. This is wrong. This is injustice. This proves the system is broken. Protests erupted in Columbus, in Cleveland, in Cincinnati, across Ohio, across the country. People marching, holding signs, chanting Kiya's name, demanding change, demanding accountability, demanding that her death means something. But Connor Grubb went home that night, free, uncharged, unconvicted, unaccountable. He shot a pregnant woman through a windshield over alleged shoplifting, killed her and her baby, and walked away because a jury said his fear was reasonable. His actions were justified. His violence was legal. Kiya's sons went to bed that night without their mother. Again, like they had for over 2 years. But now with the added knowledge that the man who killed her would never be punished, would never face consequences, would never pay for what he did. Nadine Young went to bed that night heartbroken. Again. But this time the grief was mixed with something else. Anger, rage, a deep, burning understanding that the system never intended to deliver justice, that it was designed exactly to produce this result, that police can kill, and walk away, and face nothing. November 21st, 2025. Connor Grubb walked free, not guilty on all 6 charges. Murder, assault, manslaughter, acquitted on everything. A jury of 12 people watched body camera footage of him shooting a pregnant woman through a windshield, and said it was justified, said it was reasonable, said it was legal. How does that happen? How does evidence not matter? How does a life not matter? The answer is complicated and simple, all at once. It's about the law, about self-defense standards, about how juries view police, about how our system protects cops, even when they kill, even when it's on camera, even when it's clearly wrong. Ohio law says police can use deadly force if they reasonably believe their life is in danger. Reasonably believe. That's the key phrase. Not that they actually were in danger, but that they believed they were. And that belief just has to be reasonable. Not right, just reasonable. The jury believed Connor Grubb was afraid. Believed he thought the car would hit him. Believed he thought he would die. And that belief, according to the jury, was reasonable. Even though Officer Moynihan wasn't afraid. Even though experts said Grubb created the danger. Even though Kiya was trying to escape, not attack. The jury said Grubb's fear was reasonable. And that made the killing legal. But there's more to it than law. There's bias. Implicit bias. The kind that makes juries more sympathetic to police. More willing to give them the benefit of the doubt. More likely to believe their version. More willing to accept their fear as reasonable. Even when the evidence suggests otherwise. There's also the fact that juries struggle to judge police. Struggle to say a cop committed a crime. Because cops are supposed to be the good guys. The heroes. The protectors. Convicting a cop means acknowledging the system is broken. Means acknowledging that the people we trust with power abuse it. And that's hard. Uncomfortable. Easier to believe the cop feared for his life. Easier to call it tragedy instead of crime. The civil lawsuit continues. Kiya's family is suing Blendon Township. The police department. Chief John Belford. Connor Grubb. Everyone who played a role. That case will proceed. Different standard. Different burden of proof. Preponderance of evidence instead of beyond reasonable doubt. Easier to win. But it's not the same as criminal accountability. It's money. Not justice. Not prison. Not consequences that matter. Blendon Township will likely settle. Pay money. A lot of money probably. Hundreds of thousands. Maybe millions. But that money won't come from Connor Grubb's pocket. Won't come from the police budget. It'll come from taxpayers. From insurance. From people who had nothing to do with what happened. Grubb will pay nothing. The department will pay nothing. And the cycle continues. Connor Grubb's future is uncertain. He resigned from Blendon Township Police Department. But he could apply elsewhere. Could get hired at another department. Could wear a badge again. Could carry a gun again. Could patrol streets again. Nothing stops him. No law. No regulation. No consequence. He was found not guilty. Which means legally he did nothing wrong. Which means he's employable. Free to be a cop somewhere else. That's how it works. That's how cops who kill get to keep killing. They move departments. Wandering officers. From one town to another. One tragedy to another. Until they kill again. Until another family buries a loved one. Until another community demands justice that won't come. Kiya young sons are growing up. 8 and 5 years old now. Old enough to understand their mother is gone. Old enough to know a police officer killed her. Old enough to learn that officer faced no consequences. What does that teach them? What does that tell them about justice? About their mother's worth? About their own safety? Nadine Young is raising them. Being their parent. Their stability. Their everything. But she's also fighting. Fighting to keep Kiya's memory alive. Fighting to change laws. Fighting to prevent this from happening to someone else's granddaughter. Someone else's great-granddaughter. Kiya Young was 21 years old when she died. Shot over alleged shoplifting. Alleged. Never proven. Never confirmed. Just accused. And that accusation led to her death. Led to her baby's death. Led to 2 boys growing up without their mother. She had dreams. Wanted to go back to school. Wanted to become a social worker. Wanted to help people. Wanted to make a difference. But she never got the chance. Because a store employee made an accusation. Because police responded with aggression. Because Connor Grubb stepped in front of her car. Because he drew his gun. Because he fired through her windshield. Because he killed her. Her baby girl never got a name, never took a breath, never opened her eyes, never got to live. 7 months in the womb, almost ready, almost here, but killed before birth. By a bullet meant for her mother. 2 lives, 1 bullet, 1 decision. This case joins a long list, a devastating list. Black women killed by police. Breonna Taylor, shot in her home. Tashiana Jefferson, shot through her window. Sandra Bland, died in custody. Corin Gaines, shot in front of her son. And now Kiya Young, shot in a parking lot, while pregnant, over shoplifting. Their names should be remembered. Their stories should be told. Their deaths should matter. But too often they don't. Too often the officers who kill them face nothing. Walk free, continue their lives, while families bury their daughters, their sisters, their mothers. The system that failed Kiya Young continues to fail others. Every day, in every state, police kill over 1,000 people every year in America. And less than 2% of those killings result in criminal charges. Less than 1% result in convictions. The odds of accountability are almost zero. The odds of justice are worse. That's not an accident. That's by design. The laws protect police. Qualified immunity. Reasonable belief standards. Self-defense doctrines written to favor cops. Grand juries that refuse to indict. Trial juries that refuse to convict. A system built to protect those in power. Even when they abuse it. Even when they kill. Even when it's on camera. Kiya Young deserved better. Deserved justice. Deserved accountability. Deserved a system that valued her life. Valued her baby's life. Valued black women's lives. But she didn't get it. And her family didn't get it. And her sons won't get it. Because the system never intended to give it. Grubb will face Kiya Young for killing her and her unborn daughter. Like, share, subscribe, and hit the notification bell to remember Kiya Young and demand police accountability. Stay safe, stay aware, and I'll see you in my next case.